We'll be talking about violence against women and their children, RA 9262, and we'll connect it to justifying and exempting circumstances in this video. All right, in our list of topics, we'll be discussing this one, and justifying and exempting circumstances. We know that 9262 criminalizes physical and sexual abuse. Physical and sexual abuse as criminal acts is not new to you because you've been seeing this in the revised penal code. However, 9262, violence against women and children, likewise clarifies or criminalizes psychological and economic violence against women. No? When you say psychological, it is a mental or some acts that cause mental or emotional suffering. Economic are acts, the bottom line of which are to cause the woman to become financially dependent for financial support. For financially dependent, how is it done? Acts that cause women these are acts such as unreasonable withholding of financial support, or you prevent the woman from having a source of livelihood, or you control the conjugal money. Take note, this act refers to a woman who's a spouse or previous relationship. Now, here we connect 9262 to justifying and exempting circumstances because of this battered woman syndrome provision in section 26. All right, so there's a syndrome. It's called battered woman syndrome. And so, what if there is the woman is suffering from battered woman syndrome? The law says, "You shall not incur criminal and civil liability, notwithstanding the absence of justifying circumstances of self-defense." All right, so they say, okay, since it is a mental state, well, you determine if there's battered woman syndrome with the assistance of experts or psychiatrists and psychologists. So this is the springboard that we will use to connect 9262 to justifying and exempting circumstances. Now, you go back to the revised penal code. There's Article 100, which says every person criminally liable for a felony is also civilly liable. But look, 101 says, well, even if you are criminally exempt, you are exempt from criminal liability in subdivisions 1, 2, 3, 5, and 6 of Article 12 and subdivision 4 of 11, that does not mean you are exempted from civil liability. And we explore that further. So let's look at this. Although in Article 12, 1, 2, 3, 5, and 6, there's no criminal liability, revised penal code says there is still civil liability. Subdivision 4, Article 11, even if there's no criminal liability, revised penal code says there is still civil liability. Now, these are what's in Article 12. When you talk about exempting circumstances, no, the imbecile or insane, there's still liability. It go after the estate or the guardian. Take note, this is under the revised penal code. It's still in the revised penal code. They say that the age is under 9. But take note, because of the Juvenile Justice Welfare Act, the minimum age of criminal responsibility is 15. So if you are under 15, no criminal liability. No criminal liability. So this was under the revised penal code. Now, under 9, and there's over 9 but under 15, that's under the revised penal code. But these have all been amended by the Juvenile Justice Welfare Act. So if you are under 15, no criminal liability. But if you are 15 over but under 18, you ask, is there discernment? If there is no discernment, and the discernment will be handled by the court will decide if there was discernment, but a social worker will be presented an intervention program. The child in conflict with the law shall be subjected to an intervention program. Whereas under the same Juvenile Justice Welfare Act, If there was discernment, over 15, under 18, but with discernment, there shall be diversion. It's a diversion program without making the minor go through formal court proceedings. There's a diversion and sentence. Say, for example, the minor 15 to between to 18 committed the act with discernment. Still, no imprisonment terms. There's going to be a suspended sentence until the minor becomes the child becomes 21 years old, and at 21 years old, that's when there will be a determination if the child should go to prison or not. So it's called, so with discernment, the term is diversion program. If found guilty with discernment, still suspended sentence. And then 21 years old, that's when the court will determine if there should be imprisonment. So these are the accepting circumstances, 1, 2, 3. Okay, they're skipped to number 4. So what's number 4? Accepting circumstance, there should be a lawful act which is done with due care. All right, so that's not included here. And there's compulsion of irresistible force. And there is uncontrollable fear. And number 7 is insuperable cause. So just go back to that in your codal, but the idea is, this is the springboard. And these provisions in the revised penal code must be discussed together with the Juvenile Justice Welfare Act. All right, now let's go to this one. Let's talk about Article 11, Subdivision 4. What is that? Well, it's a justifying circumstance that says, in order to avoid an evil or injury, the person does an act which causes damage to another. Similar justifying circumstances. Take note, there are requisites to it. Evil avoided actually exist. Injury feared be greater. So that's Article 11. Now, just so you don't have to go, just to give you a heads up again, what are the justifying circumstances? There's self-defense. There's a defensive relative. Take note, if the relative is relative of affinity within the same degree, and so that will include your spouse. And if it's consanguinity, this is your 4th degree is up to your first cousin. All right, my second cousin. All right, now there's a defense of a stranger, and we discussed this a while ago, avoiding greater injury. Number 5, justifying circumstances, the fulfillment of a duty or the lawful exercise of a right or office, or complying with an order issued by a superior for a lawful purpose. All right, so that's our discussion for this topic on 9262, justifying and exempting circumstances.